Yeah. Welcome back to Between Two FARS. Once again, I'm Warnke Miller here with the amazing Bob Tepfer, and we're continuing to talk about inspection and acceptance under your contract. Now, what happens if you have already inspected and accepted the goods that have been delivered, and then there's a problem?
Oh, yeah.
That's what we're going to talk about today. Revocation of acceptance. When can you do it and under what circumstances? Bob, oh my goodness, it's just happened. We've realized that this load of goods that we've accepted is no good. What do we do?
All right. There's really three bases for revoking the acceptance. And you've got a very critical point there, because presumptively, if you've accepted, it's conclusive and you've made payment, DD 250 has been executed, and you've gotten title, okay? And the three bases for revoking acceptance are latent defect, fraud, and gross mistake amounting to fraud. And yeah, they're not going to be a lot of fun to get involved in, because you got to remember, the contractor's got your money at this point. I'd always rather be the entity being sued than the entity having to sue to obtain it, because it's a much more complicated process to get the assets or get the money back from the contractor. You could have a contractor in bankruptcy. You could have a contractor who has paid the money to suppliers, material men. It's simply not a good situation to be in. But maybe you can negotiate something. Maybe they care about past performance, you hope. Maybe they're not in bankruptcy. And so what you would do, going over those three elements, latent defect is normally a defect which is not readily, what do they say, not reasonably discernible from a reasonable inspection, okay? Guess what? You've got to go back in and prove that your inspection methods were reasonable and that they were comprehensive, that you didn't overlook something, and that as a result of those reasonable inspections, you could not really have ascertained that defect, okay? That's a pretty tough burden to carry, and it's even if you get to that point, again, you have difficulty getting the money. The second one is fraud, which intentional misrepresentation of a material fact, and the government relied on it to its detriment. That's going to be a difficult one to prove up, and that's not going to be, the contractor is going to fight that very hard because of the clear implications of being involved in a fraud on a government contract, the impact that it'll have from an acquisition integrity aspect, and also from the standpoint of past performance in general, okay? The third one is gross mistake amounting to fraud, which is essentially the same elements as fraud without the intent, where there's reckless disregard with regard to some aspect. And that one's never any fun either, because what you really are going to be arguing is my inspector did a crappy job because it was a gross mistake and it should have been able to have been determined. You should have known, open parens, we should have known. And that's just no fun to go into court and argue that your inspector did a really bad job. And there's a fourth opportunity to entitlement, but once again, you've got the problem of getting the contractor back out there, and that's a warranty. And a warranty has to apply to what it says and nothing more. And it applies in a time frame, and there could be in that time frame certain aspects of maintenance or whatever that you have to demonstrate that you complied with your obligation to entitlement under the warranty. Okay, questions always become warranties. The defect could not have existed at the time or couldn't have been really that ascertainable. And it becomes a case of, do I really want to pay for a warranty, or would I rather just pay to ultimately get whatever problem it is cured? Because with warranty, you're going to pay regardless. Defect may never show up, And in those instances, you got to think hard and long about whether or not it's worth it. All of these things, they become a basis for past performance, and they also become a basis for negotiating from the standpoint of saying, look, I'm not out here without any rights at all. I have rights. Would you like to come in, make certain your past performance remains in great shape? You may not have been able to prove the past performance was in great shape. The contractor doesn't know that. But would you like to cure that? And, you know, we'll just move on from there. That becomes the basis for negotiation. So that's kind of how they fit together in that regard. But you really want to make certain you have a thorough inspection consistent with what we're entitled to under the contract before you accept, before you take title, before you pay. Because after that point in time, you're really embracing a headache.
Well, if you don't mind, let's walk through a hypothetical and talk a little bit about the things you should think about, the questions you should ask if this scenario comes in front of you. So once upon a time, we get a delivery of material that we bought. This material has been specially blended and compiled for NASA's use. It arrives. We do our basic inspection. It seems pretty good. But then later on, when we do our more detailed strength analysis on it, we realize that it is not as strong a composite material as we thought. And as we get looking into this deeper, it turns out that while the right ingredients were put in, it was cooked at too high a temperature so that the ingredients did not stay in cohesion with each other and actually began to separate from each other, thus impacting the strength of the final product. What sort of questions do we begin asking our inspector before we decide if this is something that we can attempt to revoke our experience?
Okay, the problem you're going to have there is kind of whether or not you got a performance spec which says how it has to hold up, or a design spec where we told them exactly how to do it. If you have a performance spec and you specifically said that the strength has to be to a certain point, then you're kind of home free if it's not. If you have a design spec and you told them exactly what to do, absent there being what's called a Helene Curtis or superior knowledge by the contractor, where the issue is one that they knew and we could, or, you know, we could have the case where we knew and we didn't tell them under. You know, that's a whole another episode. But the problem you have is if we had both, because you can have a problem with that. If you told them how to do it, but no matter what they did based upon your direction, it would not lead to compliance with the performance spec, that's a real headache. So you got to be very careful. And hopefully this is where your inspector is an engineer of sufficient sophistication that they played a key role at the beginning and understood that there has to be full consistency between the design and the performance. And this is a case also where, and as I hinted to Helene Curtis, where you sit back and say, is there anything we should tell them that we know that they're not going to be able to perform without that information? So that becomes kind of the key issues in that context.
If NASA were looking for the strength of this material as a key component of the deliverable, do we need to be testing for strength before we accept?
Absolutely. I mean, when you start out, if you tell me that it's a item that we need, it should be in the contract specifically, that's a requirement, and it should be tested to determine conclusively that that's the case. Because absent that, it's not going to be a latent defect. We didn't bother to test for it, and presumptively a reasonable inspection would have revealed it.
Now, sometimes, here's another hypothetical that unfortunately we run into. We have got a contractor that we have worked with for the last 25 years. They turn out good product. They frequently deliver on the contract in a timely manner, and inspection sort of becomes, yeah, we trust these guys.
Okay,
and then you find out that the batch is no good. What sort of questions do you need to be asking? Is there any recourse, any ability to be able to revoke at that point?
Well, you know, what you're hinting to at least is that the inspection was not thorough and that a waiver took place, that this friendship that we had substituted for a reasonable inspection. And because that's the case, it's not latent. You know, some argument could be made if it's done reckless disregard, you're going to be end up with the gross mistake argument that you're arguing your own inspector was terrible. Okay, that's not an argument that I've seen made a lot. It's not one that you want to make, but it's certainly something you have to sit down with everybody and explain that the relationship has nothing to do. The only thing that matters is the four corners of the contract. If it's not there, then, you know, I don't care. That's all that matters.
Yeah, this becomes more of a soft skills problem where if you're relying on relationship, you got to hope that they are caring about their past performance and their continued relationship with NASA. But sometimes when products suddenly slip like that, it's because the company itself is going through a bad merger or a hostile takeover or is running into bankruptcy issues or problems with the IRS. And all your soft skills won't save you there. And at that point, you know, the legal office can only help you with what's written in the four corners of your contract. They can't perform a miracle.
And I would speak to the contracting officer and say, if it's a vested right of the United States, that is entitlement to a certain standard, if you waive that, you can't give away a vested right of the United States, and you're putting yourself on the line with regard to either an IG audit or otherwise, because you're just giving away money. They're not performing as they're obligated to do. And that's a separate episode at some point. Yes. You don't want to go there.
So inspection and acceptance. It's always good to maintain a good relationship with your contractor, but always stick to the letter of your contract and follow the terms and conditions of your contract. Thanks so much for all of your help on helping us to elucidate and understand this very complex area of the FAR. We've really enjoyed your time today, Bob, and we look forward to seeing you again on the next episode of Between Two FARs.
Thank you.